Supreme
when
Court
this
practice
Supreme Court practice and procedure
came into force,
came in the form of a bill and it became an act. Clauses 1 and 2. Clauses 1 and 2.
Your Lords have this act in front of you.
I think one of the petitioners has filed it. It's CMA 5104. It's CMA 5104. 5104. I don't know who is 5104. It's attached with it. It's attached. Please read it. Argue as you please. Read it. Argue as you please.
By the end of
which is the petition that you?
I will be starting from 6, sir, because 6 is the one when the orders have been passed. But may I also say,
that you started with the Practice and Procedure Act. You wanted to read it.
I'll read it. But before I do that, there is an order dated 2nd of May.
Ajay sir,
we have to forget about the past.
Because we are not, don't do this.
Okay, so I'll say, let's bury the past.
Don't bury it, it's past. You can't bury the past.
All right, for the time being,
argue as if you are arguing for the first
time.
Thank you.
Well, I do say here.
I may ask a question. Khwaja Sahab, idhar dekhen.
Ji, sir.
You have endorsed the sitting of the full court, which is fine, but I'm just wondering what will happen to Section 5 in the event, if the law is upheld. There is a right of appeal that is provided under this law. In that case, then how do you visualize that right being exercised?
I was going to come to that. I'm very thankful to leadership, because if the full court is going to hear it, then I have no right of appeal.
But in the event, since we are hearing the vagaries of this law, what will happen to this right if a full court is now going to proceed with the matter?
In fact, when I go through the law, there are so many things.
वो अपनी जगह है ना जी. Let's just assume बहस हो जाएगी. Section 5 को फिर क्या होगा? Will Section 5 not be exercised by one party?
It says that an appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Khalid Sahab, if I may interject, you please proceed as you want to. Let's read the Act together. Whatever you want to comment about the Act, and please also address the query that has been addressed to you in your own manner as you wish. So let's start with the Act at least.
I would like to answer that when I'm going through this, because this is a...
So let's start reading the Act. You want to read the Act or you don't want to read the Act?
I will read the Act now. I'll start with Section 1. But first of all, let me say this one. I would just state this thing, that by the end of your honest tenure, if I'm still alive, I would have completed 50 years of practice in this honorable court.
Can you please read? No, let's not do that.
Let me say.
This is perfect time.
When I saw this Act,
let's read it. When you saw it, we're not interested.
Well, see the Section 2 thereof.
Please read the whole Act.
I read it, sir. Whereas Article 191, I'm reading the preamble, 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Now, at present, there are the 1980 rules which govern the procedure here in the Supreme Court. Before that, there were the 1956 rules. The 1980 rules were on account of a judgment which came in 1979.
Ajay Sahab, please focus.
Okay, I'm focusing myself.
We know all the 1980 rules.
Background.
No, please don't. The country expects 57,000 cases to be decided. We would love to hear you, but let's focus on your petition. Now you have started reading, you started giving the history of 1980 rules. We know that. If he'll ask a question, please answer that. But proceed with your arguments.
I have said about this 1980 rules for the simple reason that if I read now section 2, it says...
Please continue, don't jump to section 2.
All right. And whereas Article 10A is of the Constitution, mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence, and Islam guarantees right of appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, this law is being enacted. The court will see that there is no mention of item 55 of the federal legislative list as far as this preamble is concerned. It is silent. Because that is the basic, what can the parliament do? Parliament is not omnipotent. It has to go according to certain constitutional limitations. That principle of old principle that the parliament is supreme means that they are omnipotent, led by Dicey and influenced by Blackstone and Co. So we all agree that Parliament has limitations.
This law doesn't say that. Don't insert words which are not written there. Law doesn't say Parliament is omnipotent. Just restrict yourself to the act which you have challenged.
When I say this thing, that this very preamble does not mention.
It's noted. Read it on.
Okay. And whereas it is expedient to make a law providing for certain practice and procedures of the Supreme Court, it is hereby enacted as follows. This act shall be called the Supreme Court Practice and Procedures Act 2023, and it shall come into force at once. Constitution of benches, that the crucial question which arose. Every cause, appeal, or matter before the Supreme Court shall be heard and disposed of by a bench constituted by the committee comprising the Chief Justice of Pakistan and two next most senior judges in order of seniority. Now, the 1980 rules, Order 11, read in this manner. If you have to correlate, it may be important to do that.
पहले अगर इस एक्ट को पढ़ लें हम,
ताकि
हम सबको पता लग जाए कि इसमें क्या है, क्या नहीं।
Sir, which rule were you referring to?
If you want to continue like this, we'll go ahead. Because my viewpoint is this, that this frame of these rules under Article 191 is the prerogative of the Supreme Court, sitting at the full court. When they framed the 1980 rules, the entire court sat together, and in their wisdom, together they framed the rules. This abdication or this intrusion by the Parliament into the affairs of the Supreme Court prompted me to come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here on this side.
It's right here.
I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office? Is that your question?
My contention is this.
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm supporting...
So what is your legal proposition?
My legal proposition is this, that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your
This
proposition.
is my
Sahab, I
proposition.
think you
If-
should read
if
the
this-
law first, Khwaja
if this
Sahab,
is-
and then formulate
let us-
the points.
Let us first formulate.
Act पढ़ लीजिए, उसके
पढ़
बाद
लें, फिर एक-एक को
it
देखें।
is only
Then
2 pages
I-
act.
then
It
let
is
me-
only.
Let me follow the Chief Justice.
Khwaja Sahab,
and let
I-
me read the law,
Khwaja
and then
Sahab,
we make my submission.
If I may make your job easier, undoubtedly, it's sometimes very difficult and disconcerting if questions.
I know it's very difficult to answer questions.
Zara sun lijiye, Hazur. If you are receiving a lot of questions from different sides, you don't even know who is asking the questions. If one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out, either you say this entire act is ultra vires a constitution, that's one contention. If there are certain particular portions of the act which you think are ultra vires a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take, and when you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. Okay? So, please continue with the act.
Just can you take down the points and so that you can answer them. Second part of this section 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including the holding meetings and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other 2 members of the committee as the case may be. The decisions of the committee shall be by majority. Now, this is what the Parliament has enacted. And the provision which they have used is Article 191. At this stage, I would simply say this thing, that when myself and Imtiaz will be answering your question and promulgating, we would certainly refer to item 55 of the Federal Legislative List, which spells out whether the Parliament can make enactments relating to Supreme Court. If I may read 55 at this stage, it may be.
Argue as you want.
Well, all right, I'm just saying that your Lordship should note item 55 of the Federal Legislative List.
Let's read it together. You wanted to read it. Let's read it.
We'll read it together.
Khwaja Sahab, I think before going, I'm here, left side, your right side. Before going to this entry, if you want, you may read one of the Constitution. What it says.
191 also.
Who makes
In fact, I can start with Article 70, go on to 142, and then read 191 and go up to 55. Article 70. Gives the power of legislation, and it is to the effect legislative procedure. And what it says is, a bill with respect to any matter in the Federal Legislative List may originate. I will skip that. I'll go straight on to sub-clause 4 of Article 70. In this article and the succeeding provisions of the Constitution, Federal Legislative List means the Federal Legislative List in the 4th schedule, sir. Then there is Article 141. Subject to the Constitution, Majlis and Shura Parliament may make laws, including the laws having extraterritorial operation for the whole or any part of Pakistan, and the Provincial Assembly may make laws for the province or any part thereof. 142, subject to the Constitution, Majlis and Shura shall have exclusive powers to make laws with respect to any matter in the federal legislative list. Then I take your lordship to 191, which is to the effect subject to the Constitution, again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
These powers are under the Constitution, your right side. These powers are under the Constitution and the law.
Constitution and the law. I'll say also, I'll come to that also. Because when I read 55, then it will be clearer.
Khaizab, if I may request my learned brother, I know it's very disconcerting, so many judges asking questions. So we will let you argue in your own way, and we will ask you questions. You don't respond, you just note it. And because then I know your chain of thought will...
Point is noted.
Chain of thought we don't want to break.
Constitution and law. Point is noted. Constitution and law. Point is noted of my lord that what will be my proposition, and also what Justice Mansoor Ali Shah has said, that how will I go and make my propositions and to say how this law is not obtainable. But may I read 55 registered?
Please do.
Because your lord may ask questions on that. 55 of the federal legislative list. It says jurisdiction and powers of all courts can be subject to the power of the Parliament under 142 and 74.
Khaizab, just read it as is. Don't interpret it. Then you can interpret it.
Okay, I'll go along with that. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list, and to such extent as is expressly authorized by or under the Constitution.
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के खिलाफ दरखास्तों की समाअत जारी। चीफ जस्टिस काजी फाइज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। तारीख में पहली मर्तबा फुल कोर्ट की समाअत पाकिस्तान टेलीविजन न्यूज पर बराह रास्त नशर की जा रही है। पीटीवी नेशनल पर इस वक्त भी फुल समाअत की कार्रवाई बराह रास्त नशर की जा रही है।
के लिए और उनको कामयाब बनाने के लिए, और ये ही सामने आ चुकी।
Wondering what will happen to Section 5 in the event if the law is upheld. There is a right of appeal that is provided under this law. In that case, then how do you visualize that right being exercised?
I was going to come to that. I'm very thankful to leadership, because if the full court is going to hear it, then I have no right of appeal.
But in the event, since we are hearing the vagaries of this law, what will happen to this right if a full court is now going to proceed with the matter?
In fact, when I go through the law, there are so many things.
वो अपनी जगह है ना जी. Let's just assume बहस हो जाएगी. Section 5 को फिर क्या होगा? Will Section 5 not be exercised by one party?
It says that an appeal shall lie within 30 days from an order of a bench, exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Khalid Sahab, if I may interject, you please proceed as you want to. Let's read the Act together. Whatever you want to comment about the Act, and please also address the query that has been addressed to you in your own manner as you wish. So let's start the Act at least.
I would like to answer that when I'm going through this, because this is a...
So let's start reading the Act. You want to read the Act or you don't want to read the Act?
I will read the Act now. I'll start with Section 1. But first of all, let me say this one. I would just state this thing, that by the end of your honest tenure, if I'm still alive, I would have completed 50 years of practice in this honorable court.
Can you please read? No, let's not do that.
Let me say.
This is public time.
When I saw this Act,
let's read it. When you saw it, we're not interested.
Well, see the Section 2 thereof.
Please read the whole Act.
I read it, sir. Whereas Article 191, I'm reading the preamble, 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Now, at present, there are the 1980 rules which govern the procedure here in the Supreme Court. Before that, there were the 1956 rules. The 1980 rules were on account of a judgment which came in 1979.
Ajay Saab, please focus.
Okay, I'm focusing myself.
We know of the 1980 rules.
Background?
No, please don't. We don't. The country expects 57,000 cases to be decided. We would love to hear you, but let's focus on your petition. Now you have started reading, you started giving the history of 1980 rules. We know that. If we'll ask a question, please answer that. But proceed with your arguments.
I have said about this 1980 rules for the simple reason that if I read now Section 2, it says...
Please continue, don't jump to Section 2.
All right. And whereas Article 10A is of the Constitution, mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence, and Islam guarantees right of appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, this law is being enacted. The court will see that there is no mention of item 55 of the federal legislative list as far as this preamble is concerned. It is silent. Because that is the basic, what can the parliament do? Parliament is not omnipotent. It has to go according to certain constitutional limitations. That principle of old principle that the parliament is supreme means that they are omnipotent, led by Dicey and influenced by Blackstone and Co. We all agree that Parliament has limitations.
This law doesn't say that. Don't insert words which are not written there. Law doesn't say Parliament is omnipotent. Just restrict yourself to the Act which you have challenged.
When I say this thing, that this very preamble does not mention.
It's noted. Read it on.
Okay. And whereas it is expedient to make a law providing for certain practice and procedures of the Supreme Court. It is hereby enacted as follows. This Act shall be called the Supreme Court Practice and Procedure Act 2023, and it shall come into force at once. Constitution of benches, that the crucial question which arose. Every cause, appeal or matter before the Supreme Court shall be heard and disposed of by a bench constituted by the committee comprising the Chief Justice of Pakistan and two next most senior judges in order of seniority. Now, the 1980 rules, Order 11, read in this manner. Because if you have to correlate, it may be important to do that.
पहले अगर इसको पढ़ लें हम
ताकि
हम सबको पता लग जाए कि इसमें क्या है
if your lordship,
which rule were you referring
if you want to continue like this, we'll go ahead. Because my viewpoint is this, that this frame of these rules under Article 191 is the prerogative of the Supreme Court, sitting as a full court. When they framed the 1980 rules, the entire court sat together and in their wisdom, together they framed the rules. This abdication or this intrusion by the Parliament into the affairs of the Supreme Court prompted me to come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here on this side.
It's right here.
I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office. Is that your question?
My contention is this.
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm supporting...
What is your legal proposition?
My legal proposition is this, that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your proposition...
This is why I think you should read the law first, Khwaja Sahab, and then formulate the points.
Let us first formulate.
Act पढ़ लीजिए, उसके बाद
फिर एक एक को
it is only 2 pages act. It is only...
Let me follow that to keep...
Khwaja Sahab,
Let me read the law and then make my submission.
If I may make your job easier,
to constitute
undoubtedly it's sometimes very difficult and disconcerting.
फूड पैंडा होम शेफ पे मिले घर का बना खाना.
You are receiving a lot of questions from different sides. You don't even know who is asking the questions. If you're one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out either you say this entire act is ultra vires a constitution. That's one contention. If there are certain particular portions of the act which you think are ultra vires a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take. When you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. Okay? So, please continue with the act.
The second part of this section, soon after commencement of the section, the committee constituted under subsection 1 shall hold its first meeting to determine its procedures, including the holding, meeting and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other two members of the committee as the case may.
Who is that?
The decisions of the committee shall be by majority. Now, this is what the Parliament has enacted, and the provision which they have used is Article 191. At this stage, I would simply say this thing, that when I'm myself Imtiaz will be answering the
matter,
question,
or they've come purely as a matter of
we would
public
certainly refer to item 55.
No, I'm not talking that. I'm now asking a
Legislative
question of the petitioners.
which spells out
Do they have
whether
an interest
the
in any
Parliament
case where
can
they
make
brought this challenge,
enactments
or they brought it
relating to
in the
Supreme
public
Court.
interest?
If I may
Which
read
is the- what is
55
the answer?
at this stage, it may be that it's a public interest.
You have no personal interest in the matter, you or your
No,
client.
I have no personal interest.
You
because-
meaning your client.
Well, let me say this thing.
No, I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know,
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner and I'm saying this thing that we brought this petition
Take up a point
in
noted.
the interest.
You got the answer, got the answer.
in
Now
the-
please proceed. I've got the answer.
Because in the interest that,
Get-
that the law should take its course. The constitution must be upheld.
Theek.
And I am also saying that I'm sure with such preliminaries sitting there, of the whole object is that first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Khwaja Sahab, please.
We are not going to
platitudes.
I will not make a political speech.
Khwaja Sahab,
I'll refrain
Khwaja
from
Sahab,
that.
Let us proceed
Khwaja
with the
Sahab.
act.
Yes, sir.
Khwaja Sahab, just a confusion which you can answer later. So what you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches, you were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I think your Lordship has possibly not. I've not been able to explain. Section 2 stands on its own footing, and I have objection on that. Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of Section 3 is a totally different thing. It takes away the powers of this honorable court. Instead of
let us clarify.
Is it your
It takes
argument that
away
Section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court, because this court means the Chief Justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's my point. 2 and 3 have to be read independently and separate.
Now, please.
That too an exercise of administrative powers.
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine by me. Please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position. So many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions, and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Note the question, respond to it later.
To be very honest, I welcome this interruption.
Can I ask you a question? Can I ask?
Far right.
Please. What about the office of the Chief Justice after passing of this act? Don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
I noted this down, and in fact, I will say that the Chief Justice powers will be whittled down, as if this law goes through, the powers will be whittled down, but we will explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in, and the latest one is, of course, 2000.
फिर आप आंसर करने
I will continue. Let me
आप
continue.
नोट कर लें, आप बाद में कर लें.
Let me continue. Many other judges.
We'll be sitting here till 12 o'clock.
I know that, sir.
So आप जरा अपना argument करें. अभी जो हम section
Let me, on section
Court has been curtailed.
3, I will only say this thing, that this is certainly, the answer to that is that the Parliament has taken away its noted power, not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A, which provides for a fair trial. Because I will file a petition. I've not even heard, and 3 judges or 2 judges, they will decide on administrative side, and I'll be out. So the question of 184.3 will become totally redundant. This is my point. So therefore, to that extent, section 3 unheard, unless it's violated the interpretation of the Constitution in the matters where interpretation of the constitutional provision is involved. Committee shall constitute a bench comprising not less than 5 judges of the Supreme Court.
Well, I will. Do you object? First, say I object to this provision, or you endorse it.
To that extent, I will say this, sir, that in the matters of interpretation of the Constitution, when you are all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7, why not 6?
Please.
I object to this thing that this is a limitation.
No, it's not a limitation. It says not less than. It could be a full court like the present court. So are you just say, is this ultra vires the Constitution section 4? Say something, we should know.
On this, I will only say this thing, that putting a clause that the bench should be not less than 5, that possibly is expressing, shall I say, not confidence in less than 5 judges.
Noted.
Because this is very strange, because all judges are equal. Your Lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same acumen. So by saying this thing, not less than 5, then there's a question of appeal, and which is a very relevant point.
Ajay Sahab, as I understand your earlier proposition, you are satisfied that the Chief Justice in the previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that.
I have noted this thing.
Yes.
Your Lordship did not. I would not be able to explain. It's my shortcoming.
Explain later.
On the question of benches, I have stated with this thing that this power should be exercised by the full court, not by the Parliament. How the benches are to be found. I will dwell on that.
In a nutshell, you are suggesting that the powers as master of the roster in the Chief Justice were also unconstitutional.
No, sir. I'm saying this thing that under the 1980 rules, that power had been given. If all of you sitting together feel that under 191 that this should be changed, then it is your functions. It is not the function of the Parliament.
Okay, now let's proceed. We'll ask.
I'll do on that. That is the point which needs consideration. 5 is appeal. Yes, Manisha.
On section 4.
On 4.
If memory serves me right, section 4, what is the equivalent of section 4, is part of the Indian Constitution as an article of that Constitution. It was a part of the 1956 Constitution as an article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches, the question is this: that model, that aspect was not accepted by the framers of the present Constitution because they had a model both from India and from Pakistan itself. So the question is this: if that was not accepted, does this not require constitutional amendment? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models, can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
साहब मैं एक सवाल पूछ लूँ आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
भाई बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुनिए ये सवाल तो सुन लें।
जी जी।
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए, जब सुप्रीम कोर्ट एक
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं,
ठीक है, अदरवाइज तो आपकी मुश्किल काम हो जाएगा।
मैं आई एम क्वाइट I have a very patient hearing. I have worked with all of you, sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
कोई problem नहीं है. I understand what Shah Sahab is suggesting and saying, and he has mentioned this in many other cases. Yes, ma'am.
If I may ask a question as a supplemental to the question that my learned brother, my learned colleague has asked, independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you, surely the question of what the court can itself do to regulate its own practice and procedure is now encased in independence of the judiciary, and can Parliament intrude upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191, trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Yes. Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can directly take away a fundamental right?
Not an ordinary legislation.
If I will really request my colleagues that they're making, including myself, are making your life impossible. No, please, no, you are very fine.
I'm learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act, and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं.
Let me say this.
Mr. Khwaja,
Khwaja साहब section 5 से आगे पढ़ लीजिए.
Another question with regard to appeal. आप देखें हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2-member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? वहाँ तो अपील का राइट दिया, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199, here आर्टिकल 183, 84(3). तो ये क्या दोनों में
Sir, it
ये
is
गलत है तो फिर वो भी गलत
it is noted. We'll answer this thing that what Parliament can do and what Parliament can do many things. My Lord has said so. But there is a procedure provided. We'll answer that.
भाई साहब अभी जवाब की जरूरत नहीं है, आप प्लीज
I will not answer it.
पहले एक्ट को खत्म कर
Section 5 से आप आगे बढ़ लीजिए ख्वाजा साहब. You have collected 100 questions.
Just here. The law reforms ordinance of
How you will
1972,
answer?
this is the question to you, regulated a right of appeal within the High Court itself, an intra-court appeal. Was there ever a clog on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clog is there only in respect of the Supreme Court. Law reforms ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent, which is now no longer there, and also the clog was only in relation to Supreme Court. Question: is therefore the law reforms ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clog.
Mr. Noted, sir. And appreciate it. Section 5. An appeal shall lie within 30 days from an order of a bench exercised.
Do you? I'm not going to do it.
Well,
you have challenged the law. You have to do. You have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
Well, my lord, as far as Section 5 is concerned,
Is it good? Is it bad? First, tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184(3), then why is this not they included in Clause 2? Whereby my 184(3) application will be disposed of.
The way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am, no, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us what's unconstitutional about it.
Then let me explain it to them, because if I start explaining it at that age, it will take your time. But I will say this thing, that this Section 5 should have also, this right of appeal should also have been given in Section 2.
Should is different from ultra vires a constitution.
It ought to have been given.
What then? You go and move a bill in Parliament. We are saying, are you opposed to Section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे.
You have done this.
नहीं, ये नहीं, आप जवाब दीजिए ना. आपने petition लाए. This is not fair.
इसमें to make it more simple, you don't want your client to have a right of appeal.
No, sir,
First say it's unconstitutional, it's constitutional. You're not saying anything, you just... यहाँ कोई discussion होता है, sorry, not on. This is your job in office.
My lord, may I say this thing that we divided the...
Please answer the question, is this constitutional or unconstitutional?
It is unconstitutional.
I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है?
Unconstitutional.
Well, my personal opinion is this, sir, that this Section 5 goes beyond the powers which were there with the Parliament.
So now formulate a contention on that. Please formulate a contention.
For the simple reason, my lord, if an appeal is to be provided, it's a substantive right. There has to be a constitutional amendment to provide an appeal under Section 184(3).
Okay.
And this appeal through this act, an ordinary law, cannot provide.
I can't seem to reconcile your, which I appear to me to be contradictory submissions.
No, I'm simply saying
Please let me finish. Please let me finish.
Yes, ma'am.
On the one hand, you are saying, where will I go? Where will I go? Here, the Parliament has given you a right. You say it's unconstitutional. So please don't make contradictory contentions.
I'm only saying this thing, that it's a good thing that the right of appeal will give, but the manner in which it has to be given is wrong.
Please take it.
I'm saying this thing, that this one, the right of appeal given in this manner by an ordinary law.
We will not strike it down because of manner. You have to show us ultra vires the Constitution.
It is unconstitutional, sir.
But saying so, no argument.
Our argument is this, that 184(3) is a substantive provision of the Constitution. If
You are happy with no appeal.
If a right of appeal has to be given, there has to be a constitutional amendment.
Okay, point taken. Move ahead.
I just have a question to you with regard to Section 5 from what you have just said. Kindly read it again.
An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Just kindly stop. So this order, the question to you is, has two parts. The first part is, this question, this order, which is now made appealable, is it a judicial order or is it administrative type of order? And if it is a judicial order, then how can Parliament, in exercise of a legislative competence conferred by Article 191 in relation to practice and procedure, confer a right of appeal? Because, if I may, and this is the, I apologize, my question has three parts. Because if I may touch upon what my learned colleague, Mr. Justice Mansoor Ali Shah, said recently, that this is recently, meaning in the hearing of the case, that anything that this law does, the Supreme Court can itself do in exercise of rule-making power. Question therefore is, can Supreme Court confer a right of appeal in exercise of rule-making power against a judicial order under 184(3)? If the answer is no, then it seems to me logically that Parliament also can't do it, because the two things are parallel. Therefore, question, is it therefore unconstitutional?
Unconstitutional.
You don't have to give an answer.
If the right of appeal had to be given through an amendment. Yes, next is right to appoint.
आप चाहें आप हमें लिखकर तहरीरी तौर पे भी जवाब दे दीजिएगा, ठीक है? अगर आप आगे अपना आर्गुमेंट चलाते रहें, जी आगे बढ़ते हैं। 6 को पढ़िए, 6 है जी,
right to appoint counsel of choice for filing a review application under Article 188 of the Constitution. A party shall have the right to appoint counsel of its choice.
Personally की बात कोई नहीं है।
I'm not objecting to this because I feel that
okay, it's okay. Chaliye, let's get on with it. Section 6 is okay.
Okay. Application for fixation of urgent matters, application pleading urgency or seeking interim relief filed in a cause, appeal or matter shall be fixed for it. My objection on this is again this, that this is a function of the Supreme Court itself. Because this relates to the
Please
procedure.
tell us, is it ultra vires the Constitution?
It's ultra vires.
Thank you.
I just have a question to you on this, on Section 7. Now, Section 7 really relates to what is regarded as the nitty-gritty of procedural law, to the very depths of CPC, or the way we in the Sindh High Court have original side into the Sindh Chief Court rules original side. The question therefore is this: the legislative competence under Article 191, if it allows Parliament to go into so much depth into the very nitty-gritty of procedure of the court, then surely Parliament has an untrammeled power to regulate the court itself. The power to regulate, if I may adapt, is the power to destroy. Does this not effectively destroy the independence of the judiciary?
This was my very first point which I said,
Sir,
that the functions of the
is
Supreme Court have been virtually been taken over.
Is this not contrary to the fundamental principle of the Constitution, trichotomy of powers? So where the legislative organ is intruding upon the nitty-gritty and the procedural aspects which have specifically been left to the Supreme Court under Article 191, is it not an intrusion in the boundaries created by the trichotomy of powers?
That is why I say 7 is ultra-vires.
Isme Khwaja Sahab,
Yes, sir.
I think there's a very crucial and important question. The jurisprudence of this court, developed till today, has only looked at one aspect and institutional independence. What the Parliament appears to be looking at is the aspect of internal and institutional independence, where probably in the perception of the public or the Parliament, those powers exercised over the years by the Chief Justice under the rules, they actually eroded the internal and institutional independence. So, when we talk about independence of judiciary, these two aspects that have been ignored till today, they are probably more important.
Because we will certainly answer your lordship.
So, but please, one question also.
Since we have just one section, can we just finish reading it?
Sir, if I may have a supplemental on
Yes,
what my learned colleague has said. Is it possible, is it constitutionally possible that if at all, and speaking for myself and with very great respect, perhaps I do not subscribe to that view that has been expressed, but I ask a supplemental question on it. Is it constitutionally conceivable that if there is such a concern about the internal independence of the judiciary, that the solution is to put the power in the hands of Parliament? Would that not violate separation of powers? Tomorrow, what is there to prevent, and this is a question to you, what is there to prevent Parliament from making a so-called law relating to practice and procedure and provide the federal government is hereby conferred powers to make rules and for the practice and procedure of the court? There is no end to it. If at all there is any trouble, and as I say, I have very deep regard and respect for my learned colleague, all of them, but in particular Justice Athar, is this really the solution? That you say, okay, here's a problem internally to the, would that not violate? Well, I mean, no, as I say, it's constitutional. Is it even conceivable? I mean, where would that lead us?
With due respect, my lord, this is
Khwaja Sahab, ये एक बात सुनिएगा, इधर एक question.
आप इसको खत्म तो कर लेना section को. आप sorry to say,
आर्टिकल 8 खत्म कर लो.
आप पढ़ ही नहीं रहे हैं.
मैं पढ़ने का अभी पढ़ लेता हूँ सर. ये सवाल बड़े पर्टिनेंट.
आप हर चीज आप नोट कर लेना.
नोट कर भी दिया मैंने सर. करिएगा ना. मैं बता, मैंने शुरू में ये कहा था.
आप शुरू में क्या कह रहे हैं? आप आखिरी सेक्शन पढ़ लें.
मैंने शुरू में ये कहा था, आपने शरीफ साहब, और जो ये आप कह रहे हैं कि जो इंटरनल वर्किंग ऑफ द सुप्रीम कोर्ट है, उसमें किसी और का दखल नहीं होना चाहिए. ये अगर ये दखल अंदाजी होगी तो फिर ये सुप्रीम कोर्ट नहीं रहेगा.
एक बात नोट कर लीजिएगा, आपने कहा सेक्शन 5 जो अपील है वो अल्ट्रा वायरस है टू द कॉन्स्टिट्यूशन, मगर एट द सेम टाइम व्हाइल यू आर रीडिंग सेक्शन 6 it is right of review. You say that you have no objection to it. Why? Because the choice has been given to appoint the counsel of his own choice. No, when the law is totally ultra virus, then how you can say that section 6 is okay with you?
No, my own view was that at times we have the rules are there that if a lawyer says that I'm ill or I'm out of the country or I'm not well, you do allow in review.
You are declaring right of appeal ultra virus and right of review intra virus.
No, Maharaj, what I'm saying
Yes,
is that,
according to your own
that
arguments.
the question is that you cannot provide a right of appeal.
But you can
under
provide the right of
wait a
review.
minute, sir, but under 184.3, if 184.3 right of appeal is given,
سوال ہیں ان کو اتنے ایزلی برش اسائڈ نہ کیجئے. ذرا سنیے پلیز. آپ ہم دیکھیں, ہم ایک دوسرے سے ادھر بحث کرنے کے لیے نہیں بیٹھے ہیں. ہم آپ کے سننے کا, آپ نے چیلنج کیا ہے ایک قانون کو کہ یہ غیر آئینی ہے. یہ بہت فرق ہوتا ہے کہ ایک کہنے کے لیے کہ مجھے یہ قانون پسند نہیں ہے. ذرا آپ پلیز نہ خاموش رہیے 2 منٹ, ہم بھی آپ کو سن لیتے ہیں خاموشی سے, آپ بھی تھوڑا سا تحمل کا اظہار کر لیں. تو یہ بہت سے قانون ہیں شاید مجھے بھی نہیں ذاتی طور پہ پسند ہوں, ٹھیک ہے, مگر میں نے حلف اٹھایا ہے کہ میں آئین اور قانون پہ عمل کروں گا, تاکہ انلیس کہ میں اس کو سٹرائک ڈاؤن کر لوں قانون کو, وہ ایک الگ بات ہے کہ یہ الٹرا وائریز کانسٹیٹیوشن ہے. تو آپ نے کہا مائی پرسنل اوپینین ڈزنٹ میٹر, تو آپ کی بھی پرسنل اوپینین کی کوئی حیثیت نہیں ہے. آپ کو آئینی جواب ہر چیز کا دینا ہے کہ یہ اس شک, آپ نے ایک بحث میں ایک آرٹیکل آئین کا آپ نے ریفر نہیں کیا کہ یہ کس آرٹیکل کے تصادم میں ہے. دوسری بات آپ نے جو بالکل نظر انداز کر رکھی ہے, یہ ہم نے سیو موٹو کیس نہیں لیا. اگر ہمارے حقوق پہ اتنا زبردست وار پارلیمنٹ نے کیا ہوتا تو ہم نے بہت سارے کیسز میں ہم نے خود بھی اٹھا لیے کیسز کو. یہ تو آپ ہمارے طرح سے ڈیفینڈر کے طور پہ رونما ہوئے ہیں اور کہا یہ جنگ میری ہے, ٹھیک ہے. یہ صرف پروسیجر میٹر ہے, کس میں کسی کی رائٹ غائب نہیں ہو رہی, کسی کی رائٹ, ایک رائٹ کنفر ہو رہی ہے, کسی کی رائٹ چھینی نہیں جا رہی ہے. تو برائے کرم آرٹیکل 184(3) کے دائرے میں رہ کر آپ نے, جس کا آپ نے ایک لفظ نہیں ذکر کیا ہے, وہ کہتا ہے any matter of public importance. چلیں جی پبلک امپورٹنس تو ایک وہ ہے ڈیبیٹیبل کویسچن, ہم یہ کہوں گا آپ کہیں گے وہ ہے, مگر فار دا انفورسمنٹ آف فنڈامنٹل رائٹس, ٹھیک ہے, یہ اس کے پریمبل میں انہوں نے فنڈامنٹل رائٹس کا تذکرہ کر دیا ہے, جس کو آپ نے بس نظر انداز کر دیا. ٹھیک ہے, یہ بہت اچھی بات ہے کہ آپ میرے حقوق کے لیے جنگ لڑ رہے ہیں, مگر یہ میرے حقوق اور آپ کے حقوق کی نہیں بات ہے, یہ آئین کی بات ہے اور لوگوں کے حقوق کی بات ہے. یہ آرٹیکل 10(a) کا حوالہ دیتا ہے, آرٹیکل 25 کا دیتا ہے. تو آپ کھڑے ہو کر اپنی رائے آپ کالم لکھیے اخبار میں, ہمیں صرف اور صرف آئینی بحث کیجئے کہ یہ 184(3) کا جو ہم جو پاور آج استعمال کر رہے ہیں, وہ یہ ہم اپیلیٹ پاور نہیں استعمال کر رہے ہیں, نہ کوئی ہائی کورٹ نے کوئی فیصلہ کیا ہے جو ہم بیٹھے ہوئے ہیں ایز آف رائٹ اپیل سن رہے ہیں, پٹیشن فار لیو ٹو اپیل سن رہے ہیں. ہم اوریجنل جوریسڈکشن میں بیٹھ گئے, اس کی بہت محدود چیزیں, مجھے بہت سی چیزیں قانون میں شاید ناپسند ہوں, میں یہ نہیں کہہ سکتا ہوں کہ جی اس کو ایسا کر لیں کہ ایسا نہیں کرنا چاہیے تھا. تو آپ برائے کرم آپ نے ایک انفورسمنٹ آف فنڈامنٹل رائٹ سے تو آپ نے کچھ بحث ہی نہیں کی ابھی. ذرا آپ پلیز, اور ہر بات کو آپ نوٹ کیجئے, اگر آپ تو بس آپ ہر چیز کو جواب دینے لگتے ہیں بغیر سوچئے. ہر بات کی بہت اہمیت ہوتی ہے. میرے کولیگز کی جو سوال ہیں وہ بڑے اچھے سوال ہیں, ذرا غور و فکر چاہتے ہیں اور پھر جواب دیتے ہیں. اگر آپ جلدی سے کریں گے پھر آپ کو دوبارہ موقع نہیں دیں گے, پھر کہیں گے اب مجھے اچھا جواب آ گیا. پھر اب آپ پلیز 184(3) کے تقاضے بھی پورے کر لیں.
آپ کی بالکل 184(3) کے تقاضے
میرا ایک سوال بھی نوٹ کیجئے, کے پی آن دا بارڈر پلیز. آپ کیا سوچتے ہیں ایکٹ ہیز بین پاسڈ ان دی پبلک انٹرسٹ؟ کیونکہ سیکشن 5 سب سیکشن 2 says on the contrary. It appears that to do away with some of the decisions which were passed in the previous years under Article 184(3) of the Constitution, کیونکہ commencement ان کی کر دی ہے اور اس میں کوئی limitation بھی نہیں ہے. تو یہ پبلک انٹرسٹ میں پاس ہوئے یا پرسنل انٹرسٹ میں ہوئے؟
Yes, your point is noted, sir. I will not answer now. I'll answer it later.
Mr. Khwaja, another question. Please ایک اور note کر لیں. We have two provisions in the Constitution. One is Article 191 which relates to Supreme Court, and the other is 202 of the Constitution which relates to High Court. Same alfaz hai वहाँ से वहाँ पे Supreme Court, यहाँ पे High Court. Subject to the Constitution and law. Law तो बनाती है Parliament. तो आपके आर्गूमेंट से हम ये समझें कि पार्लियामेंट को आप लॉ मेकिंग में महदूद करना चाहते हैं कि आप ये तो कर सकते हैं, ये नहीं कर सकते, ये रूल्स में सुप्रीम कोर्ट खुद करेगी या हाई कोर्ट खुद करेगी.
सर मैं इसका आंसर दूंगा, बिल्कुल दूंगा, क्योंकि जब सब्जेक्ट टू कॉन्स्टिट्यूशन आ जाएगा और जो लॉ आएगा वो आपको कॉन्स्टिट्यूशन के साथ रखना पड़ेगा.
ये भी कि क्या लॉ के तहत क्या कर सकते हैं पार्लियामेंट, क्या नहीं कर सकते.
क्या नहीं कर सकते, ये इसका जवाब देंगे जी आपको. इसीलिए तो
another question, where a rule has been framed under constitutional power granted to the court.
Yes, sir.
This is with reference to section 6 that you just read. You would notice that Order 26 of the Supreme Court rules does provide for all eventualities in which a review can be filed procedurally. The question is where the Supreme Court, in exercise of constitutional powers granted by the Constitution framed rules, the Parliament can legislate and override those rules or amend those rules. That's the question. Noted. Please answer when you are answering.
Additionally, through already law or through the point is taken, sir, by already with me, and I will answer that. And I have my own views on this, that the Parliament cannot do this thing by an ordinary.
हुजूर आपके व्यूज को छोड़ दीजिए ना, आईनी तकाजे पूरे कर लेना.
Number 7 is application for fixation of urgent matters.
ये तो हो गया.
Application pleading urgency or seeking interim relief.
अच्छा, मैं आपको एक मफरूजा पे छोड़ देता हूँ. आपने दरखास्त दी, बहुत अहम केस है, अर्जेंट केस है, मैं नहीं लगाता हूँ. मेरी मर्जी. सिर्फ जवाब दे दीजिए, मेरी मर्जी. मैं 10 साल उस केस को नहीं लगाऊं, मेरी मर्जी.
मैंने इसमें कुछ नहीं कहा.
मैं आपसे सवाल पूछ रहा हूं जी. इन्होंने मेरी मर्जी ले ली, शायद मैं खुश नहीं हूं उस बात से. मेरी मर्जी में ना लगाऊं केस. एक बहुत अहम केस है, इसमें उन्होंने लिख दिया 14 दिन में आप उसका, भाई सिर्फ उसको लगा दें, कोई फैसला तो ना करें. तो मैं कहूँगा मेरी मर्जी. मैं जो ये टैक्स पेयर पैसे दे रहे हैं इस अदालत को, जो हमारा बजट है, मेरी मर्जी पे चलेगा. इस पे सवाल का जवाब दीजिए. मैं नहीं लगाता हूँ. आपका ये केस आपने फाइल किया, ठीक है, मैं नहीं लगाता इसको. आप क्या कर लोगे? कुछ भी नहीं कर सकते हैं. आपके हाथ पैर कटे हुए हैं. इन्होंने हम पे भी, मेरे कोलीग ने एक बात की इंटरनल और इंस्टीट्यूशनल इंडिपेंडेंस की. मैं 2 बातों का इजाफा भी करना चाहता हूं, और वो है, और वो आइन से पहले भी हमारे पास था, वो हमें ऊपर वाले को हिसाब देना है. ठीक है, अकाउंटेबिलिटी एंड ट्रांसपेरेंसी. आप हमें टोटली अनअकाउंटेबल बनाना चाहते हैं चीफ जस्टिस को. मैं तो बहुत खुश हूँगा, क्योंकि ये कानून अगर सस्टेन हो जाता है तो मेरे पार तो कम हो गए बाकी चीज़ों को छोड़ करके. ठीक है, इस कानून को उड़ा दे, मैं ताकतवर बन जाता हूँ. ये भी है, मैं अकाउंटेबल हूँ. ये भी एक सवाल है. आपका आइन जो शुरू होता है वो सुप्रीम कोर्ट की इंडिपेंडेंस से नहीं शुरू होता है, वो अल्लाह ताला के बाबरकत नाम से शुरू होता है. ठीक है, और हम सब everyone to exercise powers as a sacred trust. आइन में आर्टिकल 227 भी दी गई है कि शरई असूलों पे अगर आपके कोई भी कानून तसादुम करे तो वो प्रिवेल करेंगे. तो बराए करम एक इंडिपेंडेंस ऑफ द जुडिशरी से ये मतलब नहीं कि अगर इंडिपेंडेंस ऑफ जुडिशरी से मैं किसी का दरवाजा बंद कर रहा हूँ तो वो तो मैं बिल्कुल, मुझे इस्तेमाल नहीं करना चाहिए. तो आप ये पिटिशन लाते हैं, सपोज मैं चीफ जस्टिस होता, मैं इसको लगाते ही नहीं, तो हम ये बेकेस ही नहीं सुनते. कभी 10 साल पड़ा रहता, मैं मजबूत रहता चीफ जस्टिस के तौर पे. आप खुश थे उस बात से. तो बराए करम आप ये जो बार बार बात कहते हैं ना, मेरी जाय, मेरी मर्जी, मेरी नहीं है जब मैं चीफ जस्टिस हूँ. तो बराए करम हम वकीलों को बहुत ही कदर करते हैं, मगर मेरा का लफ्ज ना इस्तेमाल कीजिए. अंग्रेजी में कहते हैं मी, माई सेल्फ एंड आई आर द 3 मोस्ट यूजलेस वर्ड्स इन द इंग्लिश लैंग्वेज. इसका मैं उर्दू में तर्जुमा नहीं कर सकता हूँ, शायद आप बेहतर कर सकेंगे. बराए करम आइन का हवाले दे दीजिए किसी चीज के मुतालिक कि ये आइन के तसादुम है, वो आइन से तसादुम रखता है, ये शिक आइन से तसादुम. अभी तक मैंने आपसे वो एक लफ्ज नहीं सुना है. शुक्रिया.
मैंने तो 3-4 जगह कह दिया है कि जहाँ पे 184(3) में आप अपील का राइट दे रहे हैं थ्रू दिस ऑर्डिनरी लॉ, ये हो नहीं सकता, बिकॉज दिस कैन ओनली बी डन बाय अ कॉन्स्टिट्यूशनल अमेंडमेंट.
लफ्ज लिखा है अग्रीव पर्सन. ٹھیک ہے. اب دیکھیے اب ایک مفہوم تو یہ نکلتا ہے 184(3) کا کہ آپ ایسے معاملوں میں نہ الجھائیں اپنے آپ کو جو انفرادی نوعیت کے ہوں.
اگریڈ سر.
ذرا اگریڈ آپ سے اگری کریں یا نہ کریں, میں ذرا بات کر لوں انفرادی نوعیت کی. اگر ہم انفرادی نوعیت کے کیسز فیصلہ کرنے لگیں تو وہ بیچارہ کہاں جائے گا. میں آپ کو مثال دے دیتا ہوں. ریکوڈی کا کیس چلا, دونوں کیس فیصلہ ہو گئے تو میں اس پہ بات کر سکتا ہوں. ریکوڈی کا کیس آ گیا, ٹھیک ہے, سپریم کورٹ نے 184(3) میں اگریمنٹ اڑا دیا. ملک کو, سپریم کورٹ کو نہیں, ملک کو $6.5 بلین کی ڈز لگی. ہم نے کون سا جورسڈکشن استعمال کیا؟ ہم نے ایڈوائزری جورسڈکشن استعمال کیا. اگر ہمارے پاس یہ جورسڈکشن ہوتا, میں نہیں کہہ رہا ہوں فیصلے اچھے تھے برے تھے, میں صرف اس پہ تبصرہ کر رہا ہوں, ٹھیک ہے. اگر ہمارے پاس جورسڈکشن ہوتا ہم وہ جورسڈکشن استعمال کر رہے تھے. اب ہم نے ایڈوائزری جورسڈکشن سے معاملوں کو ٹھیک سمت رکھنے کی کوشش کی, ٹھیک ہے. آپ کہتے ہیں نہیں, ملک کو $6.5 بلین کی ڈز لگ جائے تو لگ جائے. انڈیپینڈنس آپ کی چیف جسٹس کی ساخت پہ کمی نہ آئے. یہ ایسے پاورز اپنے لیے تو نہیں چاہیے. میں اب وضاحت کر دوں, اگر آپ مجھے دینا چاہتے ہیں میں پھر بھی نہیں لینا پسند فرماؤں گا. آپ پلیز آئین کے تقاضے پورے کریں.
میں یہ میرا مقصد ہی نہیں ہے. آپ میں یہ آنسر کر دوں گا. میں یہ بالکل 184(3) کے جو کنڈیشنز ہیں وہ بھی میں آپ کے سامنے پوری کر دوں گا, اور وہ دو کنڈیشنز ہیں پبلک امپورٹنس اینڈ فنڈامنٹل رائٹس. فنڈامنٹل رائٹس میں رائٹلی سائڈ سے independence of the judiciary is a fundamental right.
Can we go back to my question before you get into the merits of all these arguments? The question is again, if the law is to be sustained, what is the effect of Section 5, which gives a right of appeal, given that a full bench is going to hear the case and decide the matter? Then that full right of appeal is no longer there. It's redundant. It doesn't exist. So what is you have read the law now. Iske upar aap bata dein ki what you have to say.
اسی کے ساتھ ایک سوال خواجہ صاحب, ادھر ہوں جی, ذرا 5 منٹ لگتے ہیں آپ کو مجھے دیکھتے ہیں.
نہیں سر, آپ اس میں
میں آپ سے صرف اسی سوال کا آگے چلتے ہیں کہ اس 4 میں لکھا ہے کہ 5 یا 5 سے زیادہ ججز کا بینچ بنا سکتے ہیں نا, تو فل کورٹ بھی بنا سکتے ہیں نا 4 میں. تو پھر 4 کو 5 کو اکٹھا پڑھیں تو اگر فل کورٹ بن گیا تو پھر اس کیس میں اپیل نہیں ہوگی. بس آپ اس کا بھی جواب دیجیے.
بلکہ تو اس میں ایڈ آن کوشچن ہوگا کہ ڈز دیٹ ناٹ مین کہ ہم پھر ونس اگین خود ہی ڈیسائیڈ کر لیں گے, جہاں ہم نہیں چاہیں گے کہ اپیل کوئی ہو کسی کیس کا تو فل بینچ بٹھا دیں گے. ڈز دیٹ اگین ناٹ اماؤنٹ ٹو اے پاور بینگ ایکسرسائزڈ بائی دا کورٹ اٹ سیلف. So the control factor that there is a right of appeal, which is a substantive right, how can we just say that that right cannot be exercised? It's a substantive right.
ایک question اور بھی اسی میں ایڈ کر لیتے ہیں اس طرف. فاجی صاحب, to your right. ہم یہ بھی دیکھیں گے through this petition there is an order of this court. The act has been suspended. Whether in presence of that order full court can be constituted or not. یہ بھی ذرا دیکھیں. Court can be constituted or not.
آپ جواب دینا پسند فرمائیں گے یا ہم shall we proceed to the next council, پھر آپ سوچ کر کے آپ جواب دے دیجئے. ٹھیک ہے,
میں نے تو پروپوزیشن کر دی.
ٹھیک ہے, آپ آئیے. کون آرگیو کرے گا نیکسٹ؟ اچھا, آپ اپنا کس پٹیشن میں ذرا بتا دیں.
تینوں میں خواجہ صاحب کے ساتھ.
جی,
تینوں میں خواجہ صاحب کے ساتھ.
To right of 2 counsel is not allowed unless you are separate petitioners.
7 میں 6 ہم بیٹھے ہیں, ایک میں آپ 7 میں میری حاضری ہو گئی.
جی چلیے بتائیے.
My lord, the proposition requires to be requested. The fundamental question is whether the parliament has the jurisdiction and the power to promulgate this act or not.
No, that is not the fundamental question, with utmost respect. The primary question is whether 184(3) can be invoked. First, you overcome that hurdle, then you argue that. So you have filed a petition not in the normal jurisdiction, you have come in original jurisdiction of the Supreme Court, which is not a right. You have to comply with certain provisions of the Constitution.
My lord, there are number of judgments.
I'm not interested in judgments, I'm talking about arguments.
I am making submission, my lord. The Supreme Court at various point of time has held that any clog on the powers of the Supreme Court or the functioning of the Supreme Court is constitutes.
حضور میں پھر آپ کو بات سمجھایا نہیں سکا. For instance, let's take income tax ordinance. ٹھیک ہے ٹھیک ہے, اس کو آپ بالکل اسٹرائک ڈاؤن کر سکتے ہیں اور اس کو چیلنج بھی کر سکتے ہیں آرٹیکل 199 میں ہائی کورٹ کے پاس. ٹھیک ہے, ہم کیوں جورسڈکشن ایکسرسائز کریں 184(3) کی؟ یہ شاید آپ کے حساب سے یہ قانون دنیا کا بدترین قانون ہو سکتا ہے. ٹھیک ہے, مگر بنیادی سوال 184 کا دروازہ جب آپ کھولیں گے تو اس میں دو چیزیں ہیں, میٹر آف پبلک امپورٹنس, سیکنگ انفورسمنٹ آف فنڈامنٹل رائٹس. بتا دیجئے کہ چلیں پہلے والوں کو ذرا گرے ایریا, دوسرے والے میں تو بتا سکتے ہیں نا فنڈامنٹل رائٹ. پارلیمنٹ اچھا قانون بنائے برا قانون بنائے, یہ ہم پارلیمنٹری ڈبیٹ ادھر نہیں کریں گے. آپ 184(3) میں ہو سکتا ہے کل کو ہائی کورٹ میں آپ یہ پٹیشن لگاتے, وہ الاؤ کر دیتے آپ کی پٹیشن, پھر آپ ہمارے پاس اپیلیٹ جورسڈکشن میں آتے, ہمارے ہاتھ بہت کھلے ہوتے. اب آپ نے بہت نیرو انتخاب کیا ہے, 184(3) کا انتخاب کیا ہے.
My Lord, there are number of judgments of the Supreme Court.
ججمنٹس حاوی نہیں ہوتے ہیں آئین پہ. اچھا 189 پڑھ لیں ذرا, یہ آپ لوگوں کے ذرا غلط فہمی کیوں ہے. 189 ایک سیکنڈ 189 پڑھ لیتے ہیں ساتھ میں, ذرا پڑھیے 189.
Deprives me of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is there, I am being condemned. I am not being heard.
Who is
the party is not being heard.
Who is, when you're using the word I, who is the I here?
Litigant. The litigant. Because
ڈریم گارڈنز لاہور میں 5, 7, 10 مرلہ 1 اور 1.5 کنال کے محدود رہائشی اور کمرشل پلاٹس آسان اقساط پر بک کروائیں. مزید معلومات کے لیے 0800
an interest in the matter, or they've come purely as a matter of public interest?
That is not provided in the Constitution.
I'm not talking that. I'm not asking
and surely the rules, are there not rules that regulate horizontal stare decisions? For example, the full court gives a judgment. If they
in the public interest, which is what is the answer?
Answer to that is that it's a public interest.
You have no personal interest in the matter. You or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
I just want to know an answer to that.
Myself and Mr. Siddiqui, we are doing this as pro bono. We are doing it because we want to know, we want to see.
I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners?
I am speaking for the petitioner, and I'm saying this thing that we brought this petition
in
the interest.
You got the answer. Got the answer. Now please proceed. I've got the answer.
I've got in the interest that the law
goes to the very system of certainty within the judicial system.
And I'm also saying that I'm
to
sure
say that your lordship are not
with
bound
such
by the
eliminatory
previous
statement
judgment
there
would
of the whole object
میرا سوال سمجھے نہیں.
First of all, there is independence of the judiciary.
میرا سوال دوبارہ سمجھ نہیں پائے. 5 other bench کا ججمنٹ اب ہم آرٹیکل 1 اگر یہ بات ہے تو یہ فل کورٹ سے بڑی کورٹ سے بڑی تو فل کورٹ نہیں ہوتی. ہمارے اوپر کوئی سمجھ رہے ہیں. اگر یہ ایشو کسی لارجر بینچ نے فیصلہ کر لیا ہوتا ہم پہ مگر ایز اے رول ادروائز ججز ڈسینڈ بھی نہیں کر بائنڈنگ ہے, ڈسینڈ بھی نہیں کر سکتے. تو اب آپ ذرا وضاحت یہ کر رہا یہ نہیں ہے کہ 4 ممبر بینچ ڈسریگارڈ کر دے گا 5 ممبر بینچ کی. بالکل یہ میری آپ سمجھ نہیں پائے. ادر کورٹس اگر ابھی تو وہ فروقوں میں ہم نہیں جانا چاہتا ہے, اس پہ پورا کورٹ بیٹھا ہے. تو یہ کوئی پریسیڈنٹ جب آپ سائٹ کرنے لکھ لیں گے تو وہ پرنسپل نہیں اپلائی کرے گا جب تک آپ آرٹیکل 184(3) کا دروازہ نہیں کھول پائیں.
یہ امتیاز صاحب, اس کو میں ذرا سمپلیفائی کر دوں ایز آئی ہیو انڈرسٹوڈ. یہ پورا لا پڑھ لیا گیا ہے, اس میں صرف 2 چیزیں ہیں. ایک, پہلے چیف جسٹس کے پاس کلی اختیار تھا کہ ڈسکریشنری چوائسز کرے, ٹھیک ہے نا. اس کو پارلیمنٹ نے ڈائلیوٹ کر دیا, ریگولیٹ کر دیا. That's all that the parliament has done. کہ انہوں نے 3 ججز کو اکٹھا کر دیا, کوئی باہر کا کوئی بھی نہیں آیا. It's still the Chief Justice and the 2 senior most judges. تو اس میں تو کسی کا بھی فنڈامنٹل رائٹ افیکٹ نہیں ہو رہا, بلکہ جو انٹرنل یا انسٹیٹیوشنل انڈیپینڈنس ہے وہ مضبوط ہو رہی ہے. سیکنڈلی, ایک رائٹ آف اپیل اس کو پرووائڈ کیا جا رہا ہے جس کے پاس پہلے کوئی رائٹ نہیں تھا. ناؤ اس 2 چیزوں کے علاوہ اس پورے قانون میں کچھ نہیں ہے, تو کون سا فنڈامنٹل رائٹس آپ پٹیشنر کا وائلیٹ ہوا ہے جس پہ آپ 184(3) میں آئے ہیں؟ یہ تو اگر
Your lordships have held.
سن لیں, اگر پارلیمنٹ نے چیف جسٹس کی اتھارٹیرینزم کو ختم کیا ہے, یہ تو آپ کو سراہنا چاہیے. یہ تو آپ کے بلکہ انڈیپینڈنس آف جوڈیشری کو سیکیور کرے گا. ہاؤ ڈز دس
Respond to this. May I respond?
اور صدیقی صاحب اسی میں ایڈ کر دوں. سوال یہ ہے کہ اگر آپ کے مطابق چیف جسٹس کی انلمیٹڈ پاورز ہی انڈیپینڈنس آف جوڈیشری ہے, یہ بھی بتائیے گا, کیونکہ اگر جس طرح مائی لرنڈ کالیگ از جسٹ مینشنڈ کہ اگر وہ وٹل ڈاؤن کر رہے ہیں پاور چیف جسٹس کی, ایک کی جگہ 3 لوگ 4 لوگ مشاورت کے ساتھ چلیں گے, تو ایک دم اس لیے کہ چیف جسٹس کی پاور کم ہو رہی ہے, انڈیپینڈنس جوڈیشری ایٹ سٹیک ہو گئی ہے. یہ نہیں دیکھ رہے کہ انڈیپینڈنس آف جوڈیشری تو بڑھ گئی ہے, کہ ایک کنسنسس سے آگے چلنے کا انتظام ہو گیا ہے کہ آپ لوگ سوچیں کہ آگے کیسے چلنا ہے, کولیجیل طریقے سے چلنا ہے. ساری دنیا میں بہرحال یہ ہو رہا ہے, کہیں دنیا میں چیف جسٹس نہیں ماسٹر آف دا روسٹر ہے, کیونکہ اب سب جگہ کہیں جائیں تو بیلٹ ہوتا ہے سال کے شروع میں, کہیں ساری فل کورٹ بیٹھتا ہے تو پھر چلتا ہے. کوئی چیف جسٹس کے بعد منجمد نہیں ہے یہ پاورز چلانے کی. تو یہ ہو رہا ہے, تو انڈیپینڈنس تو اس سے بڑھ رہی ہے جوڈیشری کی. ایک چیز تو اس چیز کو ذرا دیکھیے کہ انڈیپینڈنس بالکل کنیکٹ مت کیجئے چیف جسٹس کی اومنی پورٹنٹ پاورز کے ساتھ, کہ جیسی چیف جسٹس کی پاور کو ہم چھیڑتے ہیں انڈیپینڈنس آف جوڈیشری خطرے میں پڑ جاتی ہے. ایسا کوئی سلسلہ نہیں ہے, اس کا بھی جواب ذرا دیجیے.
Mr. Siddiqui, the fundamental question here is, who can do this? Who can do this? That's what I'm saying. I mean, is it a function of the granted by the Constitution? Is it the function of the Supreme Court?
It is a function.
Or is it the function of the Parliament? And if the Parliament exercises a function of the Supreme Court, then it is an intrusion in the independence of the judiciary, as I have understood, is your argument.
I am saying.
صدیقی صاحب ایک اس میں ذرا میں ایڈ کر دوں. 191 آپ پڑھتے ہیں نا, تو 191 میں لکھا ہے سبجیکٹ ٹو لا اینڈ دی کانسٹیٹیوشن پروسیجر بنا سکتے. تو 191 تو یہ انویزج کرتا ہے کہ قانون ہو سکتا ہے جو پریکٹس اینڈ پروسیجر کو ریگولیٹ کرے.
پارلیمنٹ کا تو نہیں ہو سکتا.
سن لیجیے, نہیں اور کہاں سے قانون لاتے ہیں آپ؟ ہم پارلیمنٹ سے لاتے ہیں پاکستان میں قانون.
ججمنٹ لا.
نہیں, لا, کانسٹیٹیوشن اینڈ دی لا,
کنونشن.
سن لیجیے. ٹو لا اینڈ دی کانسٹیٹیوشن, کہیں سے لا ایک ایگزسٹ کر سکتا ہے, آئین مانتا ہے کہ ایسا قانون ہو سکتا ہے جو کورٹ کے پروسیجر کو ریگولیٹ کرے. اب سوال آتا ہے وہ کمپٹنس کہاں سے آئے گی پارلیمنٹ؟ تو اب ہم انٹری 55 میں چلے جاتے ہیں کہ ایسی پاور وہ دے سکتا ہے کہ نہیں. اب اس کو ذرا اوور آل اسکیم میں دیکھیے کہ ہمارے پاس یہ جو سیکشن 7 پڑھا جا رہا تھا یہ وغیرہ, ہمارے پاس ارجنٹ لگتے ہیں, کتنے لگتے ہی نہیں کیسز. یہ عام روزانہ کی ایک شکایت ہے کہ ارجنٹ کیس سپریم کورٹ میں لگتا ہی نہیں ہے. چیف جسٹس صاحب نہیں لگاتے کوئی کیس, چیف جسٹس اپنی مرضی کا ایک بینچ بنا کے کوئی کیس کر دیتے ہیں. اچھا, فل کورٹ نہیں بیٹھتا. عوام کے کیسز ہیں, عوام کا ایک پورا